David Baer.
Good evening, everybody. My name is David Baer. I live at 921 Tuscaloosa Trail. I'm here as president of Save Rural Seminole, as well as the president of the Lake Tuscaloosa Homeowner Association. The borrow pit permit issue, as I suspect you all are aware, is a byproduct of what is in front of the Board of County Commissioners not long ago. I don't know if everybody here had an opportunity to listen or be present. It was very long, so I hope you didn't have to spend the whole time doing that. But just in case you weren't, I wanted to touch on it because that brings home the importance of this issue. It might seem like something that is trivial or not that substantial, but as was illustrated by how contentious that hearing was, it's not trivial. It was recognized unanimously by the commissioners that that hearing was about an attempt by a developer to twist the code that presently is in effect so that processes could be allowed for approval of that developer's efforts, which avoided review of the commissioners. That's what this is all about, where the commissioners have the opportunity and right to review substantial development plans that have the possibility of impacting our community. This is all about whether that substantive and procedural protections which are included in Chapter 65 are in effect or not, or whether they can be sidestepped. The procedural and substantive protections that are in Chapter 65 are substantial. They're pretty good. There's a lot in there. And that's what the fight was all about. Do those protections actually apply? And I really have to praise the staff and everybody here for making very good revisions. The revisions that have been made to the code do a lot. I think we're all on the same page for what the goals are. And the proposals that we've made simply try to refine that so that the goals that everybody has a better chance of not being stepped around. So I wanted to touch on them. We went through the effort of, both in George's letter, writing out what those goals were and why they're there, as well as I wrote them into your revisions to the actual code so you can see the language that would effectuate that. The first goal that we wrote was reducing 10,000 to 5,000, which has been addressed a little. Just to get an illustration of what 10,000 is, that's 2 football fields 10 feet deep. That's 500 feet by 55 feet by 10 feet deep. That's 833 dump trucks. That's a whole lot of dirt, and as was clarified by staff, that's dirt leaving the property. We're not just talking about dirt that's being dug up and moved somewhere else. It's a whole lot of dirt to move from the property. If you want to do that, you can at least ask the county commissioners and go through the procedural and substantive protections that are within Chapter 65. Thank you. The second goal that we asked for is when an exception to avoid commissioner review applies, because there are exceptions in there, and we're not asking those exceptions to be taken out, that needs to be approved by not either or the Director of Public Works or the Development Services Director, but both. This is an important issue. If you want to sidestep the commissioner's role in supervising this stuff, then have both of those high-level officials sign off on it. Doesn't seem, I think, particularly onerous. The third thing we ask is that there is guidance for when the directors review things. On line 53, I incorporated a reference to the standards that are within Chapter 65.6. Chapter 65.6 states standards that the commissioners are supposed to review applications by. I think if we're going to ask the directors to make these sorts of judgments, we should give them some guidance on how to do that. And so we included a reference to that subsection. The fourth thing is that an effort to make sure that developers cannot devise a scheme where they have a series of smaller sand mines together. And so as this is written right now, we're talking about a volume of dirt removed, which sounds good until you get to a creative person that's like, well, yeah, I'm only removing 2,000 from this lot, and then 2,000 from the next one, and the next one, and the next one. It would be a creative idea. And so we wrote in there in line 58 a way to basically reference adjacent properties. So nobody can daisy chain properties together like that to try to get around what everybody's trying to do. The fifth thing is that the broad language of exception D, which specifically references grave sites and stuff like that, it has an et cetera in it. And so mischievous lawyers, might come up with ways that et cetera means something that et cetera is not intended to. And so we wrote in there that if you're going to try to utilize that exception, then we're going to take away any incentive to, say, take out valuable sand and replace it with muck. And so we wrote that any replacing of dirt that's removed has to be done with similar type dirt. Again, just trying to avoid abuse of that exception. The sixth thing we changed was adding the testing that is contained within subsection 8. Right now, it's just limited to borrow pits from prior to 1991. We took out that age, or that chronological restriction, just so that testing applies to everything. And then finally, we added extra notice because, again, if you're going to bypass the commissioners, then let's provide some extra notice to the adjacent residents so that they can have an opportunity to maybe chime in before the directors sign off on things without any public hearing for it. And so we added that extra notice. Again, all these things I think are incredibly reasonable. They're all consistent with the intentions that everybody has from the commissioners down. And I think they help us to avoid a fight in the future where somebody is trying to avoid what we're all trying to do right now. So we encourage you all to seriously consider incorporating all the recommendations that have been made for you all. Thank you.
Thank you.